Court orders OpenAI to disclose 20 million ChatGPT logs in landmark copyright case. In a decisive ruling that could reshape the legal landscape for artificial intelligence, a federal judge has ordered OpenAI to turn over approximately 20 million ChatGPT user logs as part of ongoing copyright infringement litigation. The order, affirmed by District Judge Sidney H. Stein on January 5, 2026, rejects OpenAI's privacy arguments and underscores the high stakes of lawsuits that question how foundational copyright law applies to the AI era. The legal battle at a glance. The discovery order is a pivotal moment in the consolidated pretrial proceedings for 16 separate copyright lawsuits filed against OpenAI. These cases, centralized in the U.S. District Court for the Southern District of New York as part of a multi-district litigation, represent a significant portion of the dozens of complaints lodged by content creators against AI companies. The plaintiffs in this specific discovery dispute include major news organizations who allege their copyrighted works were used without permission to train ChatGPT. At the heart of the dispute is a simple but burdensome request. The plaintiffs sought access to a vast sample of ChatGPT user conversations to investigate how the AI model potentially reproduces or generates content based on their protected works. OpenAI argued that producing all 20 million logs was overly burdensome and proposed an alternative. The company would run its own search of the sample and produce only those conversations directly implicating the plaintiff's works. The court's rationale. Relevance outweighs burden. Judge Stein upheld Magistrate Judge Ona T. Wang's earlier discovery ruling, finding she had sufficiently balanced the competing interests of privacy and legal relevance. The court was unconvinced by OpenAI's burden argument, pointedly stating that no case law requires the court to order the least burdensome discovery possible. The judge determined that the plaintiffs' need for the raw data to potentially prove their infringement claims outweighed the logistical burden on OpenAI. OpenAI's primary legal defense relied on a prior securities case where the Second Circuit Court of Appeals blocked the discovery of recorded phone calls. Judge Stein found this precedent easily distinguishable. In the securities case, the original wiretaps were potentially illegal, and the call subjects had a strong privacy interest as they were recorded secretly. In contrast, the court noted that OpenAI's legal ownership of the ChatGPT logs is uncontested, and users voluntarily submitted their queries, creating a different privacy expectation. Implications for privacy and AI litigation. This ruling touches a raw nerve in the public debate over AI. User privacy. While the court acknowledged privacy concerns, its order establishes that in the context of civil discovery for serious copyright claims, those concerns may not shield a company from disclosing user interactions. The data, while anonymized, could reveal patterns of how generative AI models recall, paraphrase, or replicate the copyrighted material they were trained on. For the litigation itself, access to this massive dataset is a major victory for the plaintiff news organizations. Their legal teams, including Sussman Godfrey LLP and Rothwell, Fig, Ernst and Manbeck, can now analyze the logs for evidence of memorization or direct copying, key elements in proving copyright infringement. The ruling also sets a powerful procedural precedent, suggesting that AI companies may not be able to use scale or burden as a shield against discovery in similar future cases. A defining moment for AI and copyright. The order is more than a procedural step. It is a flashpoint in the fundamental clash between innovation and intellectual property. The outcome of these consolidated cases could define the boundaries of fair use for AI training and determine the responsibilities of AI developers for their models' outputs. Legal experts are watching closely, as the judge's reasoning emphasizes that novel technology does not create an exemption from standard legal process. As the case in OpenAI Incorporated copyright infringement litigation moves forward, the disclosure of these 20 million logs will provide an unprecedented look under the hood of a leading AI platform. The path is now clear for a deep forensic investigation that could answer critical, novel questions about how copyright law applies to AI, with repercussions for the entire tech industry.